GBS infection, or commonly known as Group Strep B infection, is a harmless bacterial infection which is carried by many humans, up to 25% of the population. It's carried generally in either the digestive or genital tract and is symptomless and generally harmless. It becomes an issue, however, in relation to pregnant women who do pose a risk of passing the infection on to their child during the childbirth process. The infection, if contracted by the baby, can have serious consequences for the child because it can lead on to much more serious infections. For this reason, an important charity has been set up called GBS Support, which campaigns very strongly for the NHS to change its protocol and management of GBS. At present, the NHS does not offer routine screening for women for GBS infection, and therefore if women want to know if they have the infection or not, they have to pay for this test privately. GBS Support campaigns tirelessly for this to be changed because of the horrific consequences for babies in some cases if the infection is picked up unknowingly and isn't treated. The consequences of this infection can be severe. As I said before, not all babies will contract GBS infection during the birth process. However, for those who do, they can go on to develop severe brain infections, including meningitis, and this can in turn very tragically lead to deaths. These deaths are avoidable if the medics are aware of this GBS infection in the mother or the baby. As solicitors, we have seen quite a number of these cases, and they are very upsetting indeed. It is important, therefore, if medical staff are aware that the mother has GBS infection, or indeed if they are aware that the mother has a temperature or signs of infection during labour, that action is taken and very careful treatment with antibiotics is given to either the mother or the baby to try to stop the development of severe infection subsequently. These are tragic cases, and therefore when medics do not react properly to signs and symptoms, this can constitute negligent care. I act for a young boy who's only 8 years of age at present, who suffers from severe cerebral palsy. The case came to me through his mother, and she contacted me because she felt that the care she had received at the hospital had been inadequate, and as a result of that her son had acquired an infection which was otherwise preventable. The background to this case is that the mother had gone into hospital the day before with signs of a temperature, and tests had been undertaken including a high vaginal swab. This came back as positive for Group Strep B infection. The next day the little boy's mother went into labour and was admitted to hospital, but despite this, the fact that she had a positive Group B Strep result was not picked up, and she laboured normally. During her labour, in addition, she had a very high temperature, which was a warning sign that she was suffering from an infection. Despite this, she didn't receive any antibiotic treatment during her labour, and the trust said that this was because her labour was too short to allow for it. In these circumstances, given that she had a known positive test for Group Strep B and also her very high temperature in labour, meant that it was mandatory for the hospital to give her son antibiotics as soon as possible after he was born and keep a very close eye on him indeed. Unfortunately, this simply didn't occur, and the hospital discharged the baby and he was sent home with his mother. Within 2 days, the baby had become critically ill and had collapsed and stopped breathing at home. He was rushed into hospital where they diagnosed him as suffering from severe meningitis, and despite all their best efforts, he suffered a very severe brain injury as a result of the meningitis. He has subsequently been diagnosed with cerebral palsy. As a result of his cerebral palsy, he is now wheelchair dependent and has severe cognitive problems and difficulties with both communication and behaviour. His mother has 2 other children and has very much struggled to cope with her son's injuries and disabilities, and came to us to see if we could help. As part of the case, we instructed medical experts who were experts in the field and who reviewed carefully the care received by the mother and child whilst in hospital. They were all very critical of the care, and as such we had a meeting with a barrister which resulted putting forward a claim to the hospital trust. The trust admitted liability for their failures very early on in the case, which meant that we could apply for judgment to be entered at the court and also an interim payment of damages. These damages, that is early compensation, has allowed the family to procure very much needed help, which has included bringing in a case manager, carers, moving them to suitable accommodation and allowing them to buy the aids and equipment they need to care for their child. The case is still ongoing, but it's hoped that we can bring it to settlement soon and allow the family to try to move on with their lives. Approaching a firm of solicitors for compensation is a difficult decision, and we're fully aware that seeking compensation cannot turn the clock back or make what happened change. But what it can do is achieve resolution of questions and also financial compensation for your child, which would otherwise not be the case. It's very much appreciated that the stress and financial burden of raising a disabled child is significant, and compensation can go a long way to alleviating that and providing solutions to problems. Our team offers a very specialist and highly dedicated service to our clients. We really do try to take the time to understand you as an individual family and your child, and no one is just another file number or case to us. Each case is treated individually and with a high degree of care and attention. At the team, we have very small caseloads, which means that we can really give time to our clients and listen carefully to what you have to say. This is the most important thing to you, and we're very aware that your child is your most important consideration, and we put that at the front of our minds at all times. We're very aware that families don't work on a 9-to-5 basis, and quite often parents aren't available until evenings or weekends where they have the opportunity to be able to sit down and turn their mind to the case. And therefore we do offer out-of-hours services, and we'll do our best to work around you as a family rather than expecting you to work around us. In addition, if it's easier for you, we can also come to see you within your home. Many parents prefer that because it removes the stress of having to find childcare, the time involved in travel, and also provides a more relaxed and informal environment to have meetings. It is well known that bringing a case, it can be very stressful and daunting for parents, and as such we really try and go out of our way to take that burden away from parents and move things forward as calmly and as efficiently as we possibly can. No one wants a case to go on unnecessarily, and therefore we do make every endeavour to progress things as quickly as possible. As I've said before, nothing is more important to you than your child, and that is always put first in our case, and your needs and your child's best interests are always our key concern.